Hey friends, welcome back. My name is Carly and I'm an employment attorney at the Manifest Justice Law Corporation. Today, I want to talk to y'all about the difference between a pro bono attorney and a contingency-based attorney because I have had too many people come to me and say like, wow, I have such a great attorney. They've taken on my case for free. Oh my gosh, they're pro bono. Like they're going to pay for everything and they're so cool and they're so kind and like I trust them so much. And then I'll look at the retainer agreement. And the retainer agreement, even at the top, the lawyer has self-identified themselves and says, like, I'm a pro bono attorney. And then I'm reading the retainer agreement and they're not. They're not actually pro bono. Everything in the retainer agreement says contingency-based attorney. So that's making me fear that a lot of clients are getting scammed by their attorneys. And I fucking hate to see it. So let's talk about it. Okay, a contingency-based attorney is an attorney or a firm that takes on cases and does not require the client to pay any out-of-pocket fees. Okay, so you have zero fees for a consultation, zero fees anytime you call them or email them, zero filing fees, zero fees for the mediation or the depositions or anything related to the case. Maybe there will be some like very specific language in your contingency fee agreement that has a couple of exceptions, but in general, a contingency basically means that the attorney takes on all the risk, they take on all of the fees out of pocket, and then at the end, when the case is being settled or there's a judgment issue, the attorney gets paid back. So they're not for free, they're just for free up front. That's not like a scammy thing. That's actually really awesome that a lawyer and that anyone could offer this, right? Because you genuinely do pay all the out-of-pocket fees and costs, and sometimes you don't get as much back, and so it's not a profitable case. And sometimes these cases go on for years and years and years, and so that attorney for years and years and years can invest like hundreds of thousands of dollars in cases. And there are certain kinds of situations, like at my firm, we handle employment law, so like if you've experienced a wrong at in your job, we represent solely workers. And so if a worker has been like unjustifiably discriminatorily like fired or out of retaliation fired, probably they don't have the money to pay for a lawyer out front. So there are a lot of great things about contingency based fee arrangements that I personally like. There are also some ways that they can be unethical. If an attorney is asking for equal amount or more than you in their retainer agreement, that is unethical. You are the person who was harmed. You are the person who's experienced a violation. You are the person who's had to then dedicate extra time, energy, emotionality, and resources, not only individually, but from your social network, your family, in order to advocate for yourself. So it's not right that your attorney would be walking away with the same amount that you would. You should be the person who profits the most in this situation because you're recovering. The attorney should not get as much. They should not get more than. They definitely should not be getting more than. So if you have a contingency agreement that says your attorney gets 50% or more, that's a concern, that's a problem. And I think there maybe needs to be a call to an ethical line, like that attorney possibly needs to be reported. Another way it can be unethical is when an attorney says that they're pro bono and they're not. So when they're lying and hiding the fact that they're a contingency-based attorney. So a pro bono attorney, on the opposite side, a pro bono attorney is someone who genuinely takes on the case for free, free of charge out of pocket, free of charge at later. When the case concludes, when there's a settlement or a judgment rendered, the attorney still sees none of it. That is a pro bono attorney. It's zero reward. It's soul reward. It's heart reward. It's halo reward, but it's not pocket reward. It's not financial reward. It's pro bono. It's free. It's completely free. There's no point where your attorney is going to recuperate the moolah. That's pro bono. So when a contingency-based attorney is considering themselves and calling themselves pro bono, then there's nothing in your retainer agreement that should say, and then later I get money, and then later I get a percentage, because that's not pro bono. That's contingency. And they would be misleading you, which is against our rules of professional conduct. So perhaps this could be a violation in this very hypothetical, abstract situation. So if you have an attorney or if you're looking for one, if you already have one, I want you to pull out your retainer agreement right now and read that sucker again, see what it says, okay? Also check and see if it has a lien on it, which I'll discuss in a moment. But check and see what what they call themselves, what kind of agreement they say it is, and then see what that sucker actually says. If you are looking for an attorney or you're like in the process of deciding which attorneys you're going to work with, read through the retainer agreement. I know from experience, I've been through a lawsuit before I was a lawyer. Like, I've experienced this. I understand that when you've experienced a violation, when you've been wronged and harmed and you are experiencing injuries, and you're trying to recover, and then you need an attorney and you find one who says they want to work with you, I understand how tempting it can be to just say, yes, great, fantastic, decision made, thank you, sign the dotted line. But it is such an incredibly important decision who you choose as your attorney, how you recover from this situation. That's completely determined by them. I mean, like, they have a huge say in it. They're going to take up they're going to think of the strategy. They're going to be the ones who are having private conversations with opposing counsel. They are your comrade in war. And if you don't like your comrade, and if you don't trust your comrade, and if you wouldn't like go to bat for them as well, something is off. Something is wrong. If they are putting you in a situation or positioning themselves as if they're doing some huge favor for you and you should be super grateful, that's fishy. Something is also off in that situation. Lawyers, our job is to help people. Our whole profession, our whole job is to help people. That's how we make our money. And so anyone who comes to us saying, I need help, we shouldn't be thinking, oh, great, it's my opportunity to get a bunch of money. We should be thinking, what are the ways that I can help them? Am I the best person that can help them? Can I help them? And if not, helping them get to the next person. I'm sorry, I'm a little passionate about this. I'm not sorry that I'm passionate about this, but I am sorry. I can tell I'm getting a little heated, a little worked up, because it just pisses me the fuck off, quite frankly, how many scammy, schemy sharks and bad attorneys there are out there in this field. And we don't need it. We've got enough bad shit already going on in our society, in our world, in our day-to-day lives. Like, we just don't need it. We don't need it. That's not what this profession is for. And I think that any lawyer who is abusing their position and authority and like abusing the oath that they took needs to be held accountable for that. But okay, that's just my 2 cents. And hopefully this helps. I didn't circle back to the lien. So I just really quickly want to say that a lien on a case, if you see that in your retainer agreement, a lien is basically saying that if you fire the lawyer or you stop working with them at any point, the lawyer still has an interest in your case. And so you have an obligation to still pay your lawyer even after, once the case concludes, even if you have already hired a different lawyer or you haven't been working with that original lawyer for like years, months, whatever. So double check if you have a lien. There's a lot of reasons why attorneys would put that in their retainer agreements. It's a protective measure. It's a CYA measure. It's a cover your ass situation. And there are also a lot of ways that it can be like used for good, but it's just something to look out for so that if you ever want to leave, you know that that will be another conversation to have with your attorney. Pro bono, for free, completely. Contingency, you get paid later. If you found this video was helpful, go ahead, give me a like, a comment, support, a share, let your friends know. If this video was not helpful and you felt like I did a shit job of explaining this, go ahead and drop a comment, let me know, and I'll make another video trying to do better. If this video inspired any questions, you can also drop those questions in the comments, and I will make a video responding to those questions as soon as I get the chance. All right, hope you have a beautiful day moving forward and that you're walking away feeling a little bit more empowered, a little bit more informed, and a little bit more ready to get paid. Everyone works. Not everyone is safe at work, and I'm just trying to make sure you know the difference. Have a good day. Bye, guys.